Good day everyone, I am Renz Racine M. Reyes and I'm going to report Section 145 to Section 166. Section 145. Amendment or repeal. No right or remedy in favor of or against any corporation, its stockholders, members, directors, trustees, or officers, nor any liability incurred by any such corporation, stockholders, members, directors, trustees, or officers shall be removed or impaired either by the subsequent dissolution of said corporation or by any subsequent amendment or repeal of this code or of any part thereof. Ang ibig sabihin lamang nito ay lahat ng nasabi o ang kabilang sa isang korporasyon. Ito ay ang mga stockholders, membro, director, trustees o kahit ng officers ay may pananagutan sa anumang mangyayari sa isang korporasyon. Katulad na lamang kapag nagkaroon ng bankruptcy sa isang korporasyon, lahat ng kabilang dito ay may pananagutan. Limitation on legislative power to amend or repeal. Number 1. Right against impairment of obligations of contracts and vested rights. Under Section 145, any remedy or right already acquired by or against, or any liability already incurred by any corporation, its stockholders, members, directors, trustees, or officers shall not be removed or impaired by the subsequent dissolution of said corporation or by any subsequent amendment or repeal of the code or of any part thereof. There is here a recognition of the right against impairment of the obligations of a contract or of rights. Number 2. Right survives dissolution of corporation. The reserved power of amendment, alteration, or repeal by the Congress is subject to the provision of the Constitution against impairing the obligation of contracts. Thus, an educational institution whose charter has expired in the middle of the academic year may continue holding classes up to the end of such year, where the enrollment for such classes was made prior to the date of its dissolution. Ibig sabihin lamang ay maaari niya pa rin ituloy ang nasimulang klase hanggang sa academic end of the year until the expired of its dissolution. Number 3. Right to compensation for property taken. The right to amend does not also authorize the taking of the corporation's property without just compensation. Kinakailangan pa rin ng tamang compensation para makuha ng legal ang property ng isang korporasyon. Section 146 Repealing Clause. Except as expressly provided by this code, all laws of parts thereof inconsistent with any provision of this code shall be deemed repealed. It simply means na kahit anumang ihataw na pagbibintang o kaso dito, kung hindi ito naayon sa batas o hindi ito naayon sa kaso na kinakaharap ay maituturing ito na walang bisa. Former Corporation Law repealed. Act Number 1459 as amendment, the old corporation law shall be deemed repealed by the code as the latter is intended to supplant the former. All other laws, decrees, executive orders, rules, and regulations, or parts thereof, contrary to or inconsistent with any provision of the code shall also be deemed repealed. Katulad nga ng sinabi ko kanina, kapag walang connection sa code na sinasampa ay hindi ito maituturing na o walang bisa pa rin ang kasong to. Section 147, Separability of Provisions. Should any provision of this code or any part thereof be declared invalid or unconstitutional, the other provisions, so far as they are separable, shall remain in force. Ang Section 147 ay kabaligtaran ng Section 146. May bisa ang lahat ng ito hanggat hindi ito o walang napapatunayan. Section 148. Applicability to existing corporations. All corporations lawfully existing and doing business in the Philippines on the date of the effectivity of this code and heretofore authorized, licensed, or registered by the Securities and Exchange Commission shall be deemed to have been authorized, licensed, or registered under the provision of this code, subject to the terms and conditions of its license, and shall be governed by the provisions hereof, provided that if any such corporation is affected by the new requirements of this code, said corporation shall, unless otherwise herein provided, be given a period of not more than 2 years from the effectivity of this code within which to comply with the same. Sinasabi dito na kahit authorized, licensed, or registered ang isang korporasyon dito sa Pilipinas, mapapawalang bisa ang lahat ng ito under the provision of this code. Applicability of code to existing corporations. All lawfully existing corporations, including foreign corporations licensed by the Securities and Exchange Commission before the effectivity of the code, shall be deemed licensed under the provisions of the code, and shall continue to have such authority under the terms and conditions of their license, but subject to the provisions of the code. Where any such corporation is affected by new requirements of the code, example, requirement under Section 123 that the laws of a foreign corporation allow Filipino citizens and corporation to do business in its own country or state. Said corporation shall, unless otherwise provided, have a period of not more than 2 years from the effectivity of the code within which to comply with the same. Now we will be having Section 149, Effectivity. This code shall take effect immediately upon its approval. Effectivity of the code. The Corporation Code was approved on May 1, 1980. Notwithstanding the provisions of Section 149 in the opinion of the Securities and Exchange Commission, the code did not take effect immediately upon its approval. The prior publication of laws is a requirement of constitutional due process and cannot be dispensed with. Laws take effect after 15 days following the completion of their publication in the official gazette. Publication being counted from the date of release thereof for circulation. The law may provide for its publication in a newspaper of general circulation. Before we proceed to Section 150, I will just like to remind that Section 150 to Section 166 is from revised section from 2019, and Section 145 to 149 is from 2016. Section 150, Doing Business Without a License. No foreign corporation transacting business in the Philippines without a license or its successors or assigns shall be permitted to maintain or intervene in any action, suit, or proceeding in any court or administrative agency of the Philippines, but such corporation may be sued or proceed against before Philippine courts or administrative tribunals on any valid cause of action recognized under Philippine laws. Sa madaling salita, sinasabi lang nito na wala kang karapatang maghabol pero pwede mong habulin. Section 151. Revocation of license. Without prejudice to other grounds provided under special laws, the license of a foreign corporation to transact business in the Philippines may be revoked or suspended by the commissions upon any of the following grounds. Pwede pa ding bawiin yung license mo. That's why you should maintain good standing while doing their business in the country. Here are the following grounds para ma-revoke or ma-suspend yung license ng business mo. A. Failure to file its annual report or pay any fees as required by this code. B. Failure to appoint and maintain a resident agent in the Philippines as required by this title. C. Failure, after change of its resident agent or address, to submit to the Commission a statement of such changes as required by this title. D. Failure to submit to the Commission an authenticated copy of any amendment to its articles of incorporation or bylaws or of any articles of merger or consolidation within the time prescribed by this title. E. A presentation of any material matter in any application, report, affidavit, or other document submitted by such corporation pursuant to this title. F. Failure to pay any and all taxes, imposts, assessments, or penalties, if any, lawfully due to the Philippine government or any of its agencies or political subdivisions. G. Transacting business in the Philippines outside of the purpose or purposes for which such corporation is authorized under its license. H. Transacting business in the Philippines as agent of or acting on behalf of any foreign corporation or entity not duly licensed to the business in the Philippines, or any ground as would render it unfit to transact business in the Philippines. Section 152. Issuance of Certificate of Revocation. Upon the revocation of the license to transact business in the Philippines, the Commission shall issue a corresponding certificate of revocation, furnishing a copy thereof to the appropriate government agency in the proper cases. The Commission shall also mail the notice and copy of the certificate of revocation to the corporation at its registered office in the Philippines. Magkakaroon ka ng certificate of revocation kapag nag-decide na kung ang license mo ay pwede nang ma-revoke. But the revocation of the license cannot affect the validity of the contract. And the effect of revocation is that the foreign corporation cannot seek redress from the court to enforce such contracts. And foreign corporation can no longer transact business in the Philippines. Section 153. Withdrawal of foreign corporations. Subject to existing laws and regulations, a foreign corporation licensed to transact business in the Philippines may be allowed to withdraw from the Philippines by filing a petition for withdrawal of license. No certificate of withdrawal shall be issued by the Commission unless all the following requirements are met. If the following requirements are met, it allows them to withdraw, and here are the following requirements. A. All claims which have occurred in the Philippines have been paid, compromised, or settled. B. All taxes, imposed, assessment, and penalties, if any, lawfully due to the Philippine government or any of its agencies or political subdivisions, have been paid. And C. The petition for withdrawal of license has been published once a week for 3 consecutive weeks in a newspaper of general circulation in the Philippines. These are the 3 requirements, and they will allow you to withdraw if you met the given requirements. And if the requirements are not met, they are not allowed to withdraw. Investigations, offenses, and penalties. Section 154. Investigation and prosecution of offenses. The Commission may investigate an alleged violation of the code or of rule, regulation, or order of the Commission. The Commission may publish its findings, orders, opinions, advisories, or information concerning any such violation as may be relevant to the general public or to the parties concerned, subject to the provisions of Republic Act No. 10173, otherwise known as the Data Privacy Act of 2012, and other pertinent laws. The Commission shall give reasonable notice to and coordinate with the appropriate regulatory agency prior to any such publication involving companies under their special regulatory jurisdiction. Kailangan ang mahanap mong findings, advisories, or information ay relevant and appropriate to the parties concerned. Section 155. Administration of oaths, subpoena of witnesses and documents. The Commission, through its designated officer, may administer oaths and affirmations, issue subpoena and subpoena duces tecum, take testimony in any inquiry or investigation, and may perform other acts necessary to the proceedings or to the investigation. Maaring magkaroon ng involvement ang tao para sa isang testimonies na mag-help sa mga investigations na gagawin. Let's proceed to Section 156, Cease and Desist Orders. Whenever the Commission has reasonable basis to believe that a person has violated or is about to violate this code, a rule, regulation, or order of the Commission, it may direct such person to desist from committing the act constituting the violation. The Commission may issue a cease and desist order ex parte to enjoin an act or practice which is fraudulent or can be reasonably expected to cause significant, imminent, and irreparable danger or injury to public safety or welfare. The ex parte shall be valid for a maximum period of 20 days without prejudice to the order being made permanent after due notice and hearing. Thereafter, the Commission may proceed administratively against such person in accordance with Section 158 of this Code, and or transmit evidence to the Department of Justice for preliminary investigation or criminal prosecution, and or initiate criminal prosecution for any violation of this code, rule, or regulations. In Section 157, Contempt. Any person who, without justifiable cause, fails to refuses to comply with any lawful order, decision, or subpoena issued by the Commission shall, after due notice and hearing, be held in contempt and fined in an amount not exceeding 30,000 pesos when the refusal amounts to clear and open defiance of the Commission's order, decision, or subpoena. The Commission may impose a daily fine of 1,000 pesos until the order, decision, or subpoena is complied with. Section 158. Administrative Sanctions. If, after due notice and hearing, the Commissions find that any provision of this code, rules, or regulation, or any of the Commission's order has been violated, the Commission may impose any or all of the following sanctions, taking into consideration the extent of participation, nature, effects, frequency, and seriousness of the violations. Here are the fines and penalties if you violated the law. A. Imposition of a fine ranging from 5,000 pesos to 2 million pesos and not more than 1,000 pesos for each day of continuing violation, but in no case to exceed 2 million pesos. B. Issuance of a permanent cease and desist order. C. Suspension of revocation of the certificate of incorporation. And D. Dissolution of the corporation and forfeiture of its asset under conditions entitled 14 of this code. Section 159. Unauthorized use of corporate name. Penalties. The unauthorized use of a corporate name shall be punished with a fine ranging from 10,000 pesos to 200,000 pesos. Sinasabi lang dito na kapag gumamit ka ng unauthorized corporate name, meron kang fine and penalties na makukuha. Section 160. Violation of disqualification provisions. Penalties. When, despite the knowledge of the existence of a ground for disqualification, as provided in Section 26 of this Code, a director, trustee, or officers willfully holds office or willfully conceals such disqualification, such director, trustee, or officer shall be punished with a fine ranging from 10,000 pesos to 200,000 pesos of the court and shall be permanently disqualified from being a director, trustee, or officer of any corporation. When the violation of this provision is injurious or detrimental to the public, the penalty shall be fine ranging from 20,000 pesos to 400,000 pesos. Proceeding to Section 161, Violation of duty to maintain records to allow their inspection or reproduction, penalty. The unjustified failure of refusal by the corporation or by those responsible for keeping and maintaining corporate records to comply with Sections 45, 73, 92, 128, and 177 and other pertinent rules and provisions of this Code on inspection and reproduction of records shall be punished with a fine ranging from 10,000 pesos to 200,000 pesos. at the discretion of the court, taking into consideration the seriousness of the violation and its implications. When the violation of this provision is injurious or detrimental to the public, the penalty is a fine ranging from 20,000 pesos to 400,000 pesos. The penalties imposed under this section shall be without prejudice to the Commission's exercise of its contempt powers under Section 157 hereof. In Section 162, willful certification of incomplete, inaccurate, false, or misleading statements or reports equivalent to penalties. Any person who willfully certifies a report required under this code, knowing that the same contains incomplete, inaccurate, false, or misleading information or statements, shall be punished with a fine ranging from 20,000 pesos to 200,000 pesos. When the wrongful certification is injurious or detrimental to the public, the auditor or the responsible person may also be punished with a fine ranging from 40,000 pesos to 400,000 pesos. And in Section 163, Independent Auditor Collusion. An independent auditor who, in collusion with the corporation's directors or representatives, certifies that corporation financial statements, despite its incompleteness or inaccuracy, its failure to give a fair and accurate presentation of the corporation's condition, or despite containing false or misleading statements, shall be punished with a fine ranging from 80,000 pesos to 500,000 pesos. When the statement or report certified is fraudulent or has the effect of causing injury to the general public, the auditor or responsible officers may be punished with a fine ranging from 100,000 pesos to 600,000 pesos. Section 164, Obtaining corporate registration through fraud. Those responsible for the formation of a corporation through fraud, or who assisted directly or indirectly therein, shall be punished with a fine ranging from 200,000 pesos to 2 million pesos. When the violation of this provision is injurious or detrimental to the public, the penalty is a fine ranging from 400,000 pesos to 5 million pesos. Section 165, Fraudulent Conduct of Business. A corporation that conducts its business through fraud shall be punished with a fine ranging from 200,000 pesos to 2 million pesos. When the violation of the provision is injurious or detrimental to the public, the penalty is a fine ranging from 400,000 pesos to 5 million pesos. Lastly, Section 16, Acting as intermediaries for graft and corrupt practices equals penalties. A corporation used for fraud or for committing or concealing graft and corrupt practices as defined under pertinent statutes shall be liable for a fine ranging from 100,000 pesos to 5 million pesos. When there is a finding that any of its directors, officers, employees, agents, or representatives are engaged in graft and corrupt practices, the corporation's failure to install A. Safeguards for the transparent and lawful delivery of services, and B. Policies, code of ethics, and procedures against graft and corruption shall be prima facie evidence of corporate liability under this section. And this is the end of my report. This is Section 144 to Section 166, and this is end. Thank you. I'm Reyes Franz Racine M. from BSA 401.